Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing competition law in Canada. Competition law is a field of law that seeks to maintain market competition by regulating anti-competitive conduct by companies. It's known in the U.S. as antitrust law. On February 7th of this year, the Federal Minister of Innovation announced that the government will be undertaking a review of the Competition Act. And the Competition Bureau, Canada's competition regulator and enforcement agency, released a detailed list of recommendations for reform. Competition law and the changes to these laws have a direct impact on consumers. Competition laws prevent unfair and misleading marketing practices, and they protect consumers by regulating anti-competitive practices like price fixing and monopolies. What might these changes mean for consumers and businesses in Canada? Here to discuss this today are two experts. Vas Bednar is the Executive Director of the Masters of Public Policy program and an adjunct professor. Keldon Bester is a fellow for the Center for International Governance and Innovation. Thank you both so much for joining us today. So Vas, this is the first comprehensive review of the Competition Act in 35 years. So what do you think is the biggest priority for reform?
So I think there are two major priorities for reform. The first is making sure that this comprehensive review actually happens. So though a review of the act was mentioned in the Toronto Star exclusive that accompanied the minister's very important announcement, if you dig into the press release, details on that review aren't quite there yet. So it's good that Canadians can anticipate this and kind of push for it. The second thing that I think is so important and fundamental is that we get out beyond the usual suspects and that the consultation is comprehensive, not just in terms of the issues that it surveys, but that it's not limited to economists and lawyers, and that we're also speaking to entrepreneurs, small business owners, workers, and consumers themselves.
Keldon, same question for you. What do you think the priority for reform should be?
I think an area of the law that should have focus is merger control, which is, what determines how companies can purchase, how easily companies can purchase their rivals and eliminate competition. The reason for that is mergers are a way for, dominant firms to often permanently remove competition from a market and reduce the amount of options that are available for consumers and businesses that once depended on that competition. And right now, Canada has very weak merger laws, and they favor concentration, the elimination of competitors, and trading off harms to consumers for alleged cost savings. And stronger merger law means that companies have to work harder to show that a merger will actually benefit Canadians, and it encourages firms to grow independently instead of just swallowing up rivals. So if I had to pick one area, I would pick mergers.
Keldon, I want to put this in sort of real terms for our listeners. Can you give an example of a large merger and how it might impact consumers? Like, what would be the tangible impact on a regular Canadian of a merger?
Absolutely. A great example comes from a bit of an older case. Superior Propane, which was a merger between propane distributors, which unfortunately resulted in the creation of literal monopolies where consumers had only one option to buy propane, often used for heating homes, and that merger was allowed. So that's a tangible example of firms or consumers rather being left with no choice as a result of our competition law.
Vas, sort of a similar question for you. Can you put this into real terms for our viewers who are consumers and what competition law means for them in terms of either mergers or another area of competition law?
So the outcomes of competition tend to manifest for us in our everyday lives in terms of choice, product, quality, and innovation. And another example that's recently been making headlines, and it's relevant to both lawyers and home buyers, is with a particular company called Dye & Durham. So Dye & Durham's strategy is to, achieve a monopoly or be monopolistic. And they've jacked up prices by more than 400% for their legal software. These price increases are being passed on directly to consumers when they're making a major purchase, maybe the biggest purchase of their lives with a house, and that cost is kind of hidden there a little bit. But what it shows us is when there's not enough competitors and people don't have an alternative choice, they're powerless, and they have to pay a price that probably just isn't competitive. And in this period of inflation, I think it's all the more important for us to care really deeply about competition in Canada.
We've got to go to commercial break, but we're going to continue this conversation right after. Welcome back to Canadian Justice, where we're discussing competition law in Canada. Now, Vas, you've written about the need for competition law in Canada to address what's called self-preferencing, especially in digital companies. So what exactly is self-preferencing, and how does it limit competition? What does it mean for consumers?
All right. Self-preferencing is one of 9 case studies that I looked at in an independent working paper with Robin Chabon and Anna Quarry. It's basically a behavior where market operators, so digital platforms that are both owned by a company that they also operate within, they give self-preferential treatment to their products over others. So when you're searching for something, even though another product might be much cheaper, might have much higher ratings, right? In theory, it's of higher quality. No matter what, your product compared to that of the parent company are depressed in search. I feel I'm not doing it succinctly, but I can give you an example that'll bring it to life more effectively. If you go online to order your groceries with something like No Frills owned by Loblaw, as I do, no matter what, if you choose, if you're searching for cookies, which I always am, those President's Choice cookies are going to come up first. Now that is an example of a private label brand that's being self-preferenced on a platform. And what that means for competitors is that when they're participating as third parties in that marketplace, they are subject to the parent company that's setting the terms of competition in that marketplace and creating an inability for them to show up high in search rankings. So we should talk about it and think about whether our laws care about this. Is this an anti-competitive behavior?
So, I mean, can you give me an example of how that hurts consumers, though? Because, I mean, I think a lot of consumers know that the PC brand is a Loblaw's brand, right? But there are a lot of other examples where they might not necessarily know that. And I think one of those times is often on Amazon.
Absolutely. So, I mean, it hurts consumers. There's a huge blindness for consumers, right? The expectation that consumers have may not be aligned with the experience they have when they're searching. So at the very least, one of the things we've put forward is, self-preferencing could be a form of deceptive advertising. Maybe it should be labeled. Maybe it should say owned by Amazon, right? Not everything that's owned by Amazon is labeled as an Amazon basic product per se. But again, this is happening. It's not just the largest technology firms that's engaging in this behavior, which is why it's so important to look at both the behavior and the behavior in Canada. The Bay is an online third-party marketplace. Canadian Tire, Mark's, which was formerly Mark's Work Warehouse. Those are Canadian examples where consumers don't know that it's happening necessarily, and competitors are having competition stifled.
Now, Keldon, I want to turn to you for your perspective on competition law and how it applies in the digital sphere. Is there a gap in our competition law that makes it easier for digital platforms to sort of use market dominance to their advantage?
Yeah, I think that problems in digital markets are really an extension of the problems in Canadian competition law in more traditional markets. I'll give an example from before. We were talking about mergers, where our laws really allow competitors to buy up their rivals. In digital markets, we talk a lot about small companies growing very quickly to become competitive challenges. Our current law with respect to digital markets would say, if the company is still small, well, that's probably not going to be a big deal, and it's going to allow the company to purchase that small player that could very quickly become a competitor. So again, I would say the problems we have with traditional markets, a weak merger law is magnified in digital markets where competitors can emerge quite quickly, but not appear to be a threat sort of today.
Now, Vas, we've got about a minute, but one of the big stories in the U.S. on sort of digital digital market dominance behavior was with some app stores that were prohibiting competitors from listing apps on their store. What would Canadian law have any applicability to things like that?
We've taken no cases in Canada on this activity of gatekeeping, and yet we're seeing other regulators, competition regulators, caring deeply about this, both in terms of the apps that can come forward in the App Store, both in terms of the 30% commission that developers tend to have to pay. This tends to be a norm, and also in terms of the gatekeeping ability to force somebody to use the proprietary payment system. So does Canadian competition law care about this right now? We haven't seen any cases come forward, but this is the right question to be asking. Can our competition law even contemplate this? And is the evidentiary burden too high for us to consider a case?
We've got to go to commercial break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing competition law in Canada and some proposals to reform competition law. Now, Keldon, you've written a lot about proposals from the Competition Bureau to change how mergers get approved. And one of the things that the Bureau has proposed in particular is to eliminate what's called the efficiencies defense for mergers. And this would be a pretty big change to Canadian competition law, but let's break it down. First, can you tell me what the efficiencies defense is, how it works, and maybe give an example of how it has worked in the past?
Absolutely. So the efficiencies defense, which it truly is, unique to Canada and the way we treat this, allows merging parties to offset harms, higher prices, lower quality, worse service, with the idea that the merger is going to grant them cost savings. And those cost savings can and do include, layoffs. They say, well, sure, we're going to raise prices on consumers, but don't worry, we're going to fire some people as well. And that's going to improve our bottom line. And our law actually rewards that. An example of how it's used is really just that. We don't see publicly the claims unless the Bureau brings a challenge, but we know, for example, that in 2017, the Tervita merger, and I think this was Commissioner John Peckman at the time saying, this merger was allowed for the layoffs that were equivalent to sort of one, or cost savings that were equivalent to sort of one Bureau staffer. So what it boils down to is trading off the harms of the mergers with the idea that the company may be more profitable as a result of the merger. We really are an outlier. No other country really treats efficiencies in this sort of weighing manner. Many countries consider them, but they don't trade them off so explicitly.
So Vas, why is that? Why does Canada have this defense when I know that this is considered in other jurisdictions? Efficiencies are part of the calculus, but they're not so explicitly a defense the way it is in Canada. So how did this doctrine become a part of Canadian law? What's the rationale for having it?
The rationale, it hasn't aged well, is what it seems. Back to your earlier point, it's been 35, 36 years. Well, that's the same age. That's about as long as we've had the efficiency defense. And it is absolutely up for renewal in terms of, is it serving those goals that we might have for competition in Canada? And our current commissioner has been very vocal about not only that this makes Canada an outlier, but in his fall Canada Bar Association speech, he made the point that they're seeing more and more of this defense being invoked and how impactful it can be for consumers. And also it raises significant practical challenges for the Bureau to estimate and measure anti-competitive harm. Those are great reasons for us to call it into question, take a good hard look, and consider whether and what reforms could serve both businesses and consumers more effectively.
Now, Keldon, this is the Bureau's proposal is to get rid of this defense. How likely do you think that is to happen? I mean, the minister hasn't explicitly mentioned it as far as I know. Do you think that this is going to make it into the set of reforms, or is this kind of maybe wishful thinking from the Bureau?
I certainly hope so. It's, as I mentioned, Commissioner Boswell is not the first commissioner to raise this issue. And I think it boils down to that the competition legal community understands that this is something that benefits their clients, and those in favor of mergers, including the merging parties, or parties that plan to merge in the future, know that this makes it easier for them. So while I'm hopeful that the efficiencies defense, that Canada kind of gets with the program, globally, it'll be a tough fight, just to get rid of this exception.
Now, we've only got about a minute left, but Keldon, I just wanted to briefly ask you about one of the other proposed changes, which relates to injunctions to stop mergers. What's going on there?
So there was a really unfortunate decision last summer where the Bureau tried to gain an injunction, and the Competition Tribunal, who hears these cases, said, well, I won't grant you the injunction because you haven't shown me an initial estimate of the harms of this transaction. And that sounds like a fair thing to ask, but what the tribunal was asking the Bureau to do was to compress months of complex economic work into maybe a week or two, and then provide that to the tribunal for it to weigh against the efficiencies claims that the parties were making. And not only is that difficult to do, but extremely risky.
We've got to go to commercial, but we're going to continue this conversation when we're back. Welcome back to Canadian Justice, where we're discussing competition law in Canada and some proposed changes. Now, Vas, there has been some speculation there will be prohibitions on what are called buy-side agreements between competitors. So we know that competitors can't enter agreements, for example, to fix prices. But what about regulations on agreements on things related to wages, not making companies who compete with each other agreeing to fix wages, or entering into no poaching agreements among employees? Are those currently subject to regulation, and should they be?
So in a statement published in November of 2020, the Competition Bureau stated that it does not have the power to take on criminal cases against wage fixing or no poach agreements between companies. And this is a really interesting extension where competition law could be updated to incorporate more of these labor aspects, right? There's research showing that worker welfare is just not a priority in Canadian competition research. But the other thing is there could be a role for the provinces here, right? Not everything that's competition related needs to be dealt with through the act. So I'm absolutely optimistic that we'll go forward and consider this in a more clear way. But hey, we could be taking an all-of-government approach and look at other policy levers that we have that could be more appropriate here.
Great point. Now, Keldon, there was a comment by the minister about addressing something called drip pricing, which is a practice where consumers sort of advertised a low price for a product that's not actually ever attainable because of fees that pile up on top of it. So this is a practice not expressly addressed by the Competition Act. So can you tell us how common it is and give a few examples of it, and if you think we're likely to see some regulation of that?
How common it is, I'm unsure, but I think almost all of us have experienced it. I think a great example is buying, a ticket for travel, and it seeming, very attractive, but by the end of it, you've added on 1, 2, 3 things that you were going to buy anyway, and the price has, doubled or tripled, and suddenly it doesn't seem as attractive initially. And the way that the Competition Bureau has tackled this in the past is through its deceptive marketing practices law, and there have been successful cases, but it's still a gray area that requires the Competition Bureau to go to the tribunal and to try to render a decision. So that would be a quick win, you could say, if it were made explicit, and companies would then likely be much less likely to engage in the practice.
And I think the fact that the minister explicitly mentioned it makes it more likely to be included in that package of changes. Now, Vas, I just want to get briefly, we've got about a minute and a half left, a take on how Canada's competition law compares to some of our allies, some of our neighbors. Are we doing well? Are we giving good consumer protection? Or are we kind of lagging, especially in the digital space?
I'll say we aren't doing well at all. I mean, the OECD recently released a competition handbook on digital, and this should be a great resource for us. The good news is we have an opportunity to leapfrog, to learn from literature elsewhere. There's a lot of deep scholarship, and there's also a lot of really productive and provocative policy documents from our peer jurisdictions. And that's really Canada in a digital context. I think consumers, I'm so glad you keep bringing up actual people, because they're who competition law fundamentally affects. And they're the very same people that need to keep pushing our decision makers to stay on and take on the huge challenge of modernizing Canada's Competition Act so that we can get a little bit closer to, convergence with other global actors.
Keldon, we've only got about 30 seconds. What's the timeline for these changes?
I'm not sure. We don't have a consultation announced yet, so we kind of wait with bated breath, but until then, we have no timeline.
Well, I want to thank both of you so much for coming on to share your expertise today. I think competition law is a really fascinating area of law. I hope our viewers enjoyed this conversation today, and that they remember that at its core, this is an area of law that's supposed to be designed to protect consumers, individual consumers. So thank you both for coming on and sharing your perspective.
Thanks for having us.
We've heard today that changes to Canada's competition law may be coming. Competition law is designed to ensure there's enough market competition to stop mergers that could create monopolies and exploiting consumers, to stop price fixing and misleading advertising. And we've heard about serious gaps in our existing law and how Canada may be lagging internationally. What changes would you like to see to better protect Canadian consumers and ensure our markets are competitive? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.